Hi everyone, welcome to Impact Academy. So today let us look at model paper 1 of Indian Polity. Okay. So these one-liners are also very important. Only if you are very strong with the one-liners, we can answer uh, tough questions also. Okay. So be very strong in your uh, fundamentals. Okay. So if you look at the Montague Chelmsford reforms, proposals or reforms of 1919. Okay. So this is a very fundamental thing, right? Morley Minto reforms. So if you look at, okay, Morley Minto Reforms 1909 and Government of India Act 1990. So this is basically Government of India Act. Okay, this is a Council's Act. This is a GOI Act. Again, GOI Act of 1935 is also very important. So if you look at 1919, Montagu Chelmsford reforms. Okay, uh, responsible government. Okay, they tried to make it a responsible government. Office of the High Commissioner of India was created in London. Fine. Indian legislature became bicameral for the first time. So this is also very important because for the first time became bicameral. That is Lok Sabha, Rajya Sabha. For example, you have an upper house and a lower house. That is called bicameralism. Okay, so at that time Lok Sabha, Rajya Sabha was not there, but it's like the upper house, lower house, etc. When there are two houses, it's called bicameral. So communal representation extended to six Christians, Anglo-Indians, and Muslims. So, so if you look at communal representation for the first time, then it is Councils Act of 1909. Okay. In the Indian Councils Act of 1909, that is the Parliamentary reforms, introduction of separate electors for Muslims for the first time was introduced in 1909. Then that was further extended to six Christians, Anglo-Indians, Muslims in 1919. Secretary of State for India now to be paid from the British revenue. Diarchy in provinces. This is again one frequently asked question. Okay, diarchy is you have this concept of transferred subjects and reserved subjects. So transferred subjects are with governor and ministers. So those are like even Indians and everyone gets a chance to vote and everything. Reserved subjects are only governor with executives. That is, the important subjects are put as reserved subjects so that Indians do not have direct power over it. Okay, so this concept of dual governance, one reserved and one transferred subjects, is called diarchy, and it was introduced in provinces, that is the state level. Okay, next in 1935, diarchy was abolished in center. So introduced bicameralism in 6 out of 11 provinces. Okay, so basically, what you say, a separate electorate for Muslims was introduced in 1909, that was extended in 1919, and bicameralism was in first time introduced in 1919 and extended in 1935. So remember it like that. So what the question is saying is the Montagu Chelmsford reforms are related to. So out of these options, you can say they're not exactly educational, social, or political administration. So reforms in political administration can also be one thing, but you can also go for constitutional reforms also. Okay, so it's a tricky question. You can go for constitutional reforms because it's a Government of India Act. Okay, it's not just a Councils Act or a what is a regulating act or anything. So it's a GOI Act of India, and if you look carefully, it's also a lot of it is related to the political administration also. Okay, so you can even go for this answer. Reforms in political administration may also be a right because constitution, we didn't have a constitution by then. Okay, so you have to choose either this or this. So constitutional reforms is fine, or you can go for reforms in political administration also. That also is a suitable answer. So how many part schedules and sections are there in the Andhra Pradesh State Reorganization Act 2014? So especially when you're preparing for Group 2, Group 1 and all these things, AP Reorganization Act 2014 is very important. Okay, if you are preparing exclusively for civil services, then maybe not so much. Anyway, it contains 12 parts, 13 schedules and 108 sections. Very important. Okay, 12 parts, 13 schedules and 108 sections. Also try to go through what are the parts, what are the important sections. For example, section 90. Okay, section 90 is about Polavaram project. Okay, and what are the important schedules, all the thing you have to go through. So to uphold and protect the sovereignty, unity, and integrity of India is a provision made in the fundamental duties. Okay, to uphold the protect the sovereignty, unity, and integrity of India. So if you look at the fundamental duties, okay, it's Article 51A. Article 51A is fundamental duties, right? Okay, so you have to go through this fundamental duties multiple times, and just by looking at the statement, you have to identify what it is. Okay, And if possible, try to remember the subsections also. But if that is a little bit difficult, at least remember this last one is K. Okay, last one is K, and this was added by the 86th Constitutional Amendment Act 2002. So this is basically the right to education, right? 86th Constitutional Amendment Act 2002. It is saying to provide opportunities for education to his child or what between the age of 6 and 14. That is right to education. The state will provide free education between 6 to 14, Article 21A, and Article 45. Okay, Article 45 deals with up to 6. Previously, Article 45 used to deal with education. Okay, now Article with this 86th Constitutional Amendment Act, a new fundamental duty was added, and also Article 45 has been the subject matter has been changed to provide education up to 6 years. Okay, from 6 to 14 years, a separate article, Article 21A, is added. So all those are very important articles. So look at this. To abide by the Constitution, respect its ideals, institutions, national flag, anthem, to cherish and follow the noble ideas that inspired the national struggle for freedom, to uphold and protect the sovereignty, unity, and integrity of India. Fine, this one. Defend the country and render national service when called upon to do so. To promote harmony and the spirit of common brotherhood amongst all people of India, transcending religious, linguistic, regional, or sectional diversities, and to renounce practices derogatory to the dignity of women. So remember E. Okay, this is frequently asked because women is a very important topic. So at least remember E. One thing, remember K. Okay, K is the last one. E is women, and preserve rich heritage. Okay, environment, scientific temper, humanism, public property, abjure violence. So you can remember I also maybe because recently a lot of protests and public property damage, everything has happened. So try to at least one or two. Okay, try to remember E, dignity of women. First one is to abide by the constitution, respect everything, and last one is to provide opportunities for the child. And last one is K. And this is 86th Constitutional Amendment Act of 2002, and also 21A. Okay, 21A is right to education. Previously, it was not there. Previously, 45 provision for free and compulsory education for children. Okay, so previously 45 used to contain the education part. Later, with 86 Constitutional Amendment Act, 21A has been added, and 45 Article 45 is up to 6 years. Okay, Article 45 is up to 6 years, and 21A is from 6 to 14. Article 21A, compulsory education between 6 to 14 years. That is the state will provide. And 51A is the fundamental duties. Okay, and in fundamental duties, it is the duty of every parent to provide his ward with what you say opportunity to pursue education, especially between 6 to 14 years. Anyway, to uphold and protect the sovereignty, unity, and integrity of India is a provision made in the fundamental duties. Okay, it's part of the fundamental duties. So this fundamental rights, preamble, directive principles, everything, each and every article you have to remember, especially when you are preparing for Group 2. Even for civils and Group 1 also, it is very beneficial. So the ideal of welfare state in the Indian Constitution is enshrined in the directive principles of state policy. Okay. So what do you mean by welfare? So if you look at the directive principles of state policy, okay. So basically all these free legal aid, participation of workers, and all these things that comes under the directive principles of state policy, right? So these are the directive principles of state policy. All these things you have to remember. Okay, including each and every article. Now you may not remember sentences as such. Try to remember roughly. So 36 and all not required. 37 not required. So 38 is to secure social order for promotion of welfare of the people. Okay. So welfare, when you are talking about welfare of the people, all these free schemes and everything, it's all coming from the directive principles of state policy. So 38 is welfare of the people. So 39 is equal pay for equal work. Remember that. Okay. D 39D is equal pay for equal work and the right to adequate means of livelihood for all citizens. Manrega. Okay. So you can say which article is the source for Mahatma Gandhi National Rural Employment Guarantee Scheme because that's a very famous scheme throughout India, right? People are getting employment and getting some form of salary, some form of wages. Okay, not salary. So that is 39D. Sorry, 39A. Okay, 39A you can say is the basis for Manrega. Equitable distribution of material resources. Okay, prevention of concentration of wealth and means of protection. Okay, equal pay for equal work, again very important. And health and strength of workers, children. Okay, development of children. So 39 is basically equal pay for equal work, right of livelihood, etc. 39A is promote equal justice and free legal aid. This is very important. Okay, because it is free legal aid. Okay, 39A. Now 39B is also there. Cooperative societies. Try to remember that. 40 very important. Gandhian principle. Organization of village panchayats. 41 is right to work. Okay, and public assistance. So these old age pensions, disability pensions, and all those are under 45. So such a question can be asked. Okay, so the government has come up with a new scheme for what is the pensions. Okay, under which article, which of the article, which of the article it is possible? Then you can say Article 41. So 42 is just and humane conditions of work and maternity relief. 43 is living wage. Okay, promote cottage industries in rural areas. So not 39. This is 43B. I'm sorry, 39A is only there. Promote equal justice and free. So it's basically 43A is participation of workers in management of industries. Okay, then 43B is promotion of cooperative societies, not 39B, 43B. 44 is very, very important, uniform civil code for citizens, because it is currently in use. Okay, uniform civil code is 44. 45 we've already seen. Okay, up to 6 years. Okay, up to 6 years, to provide early childhood care and education to children below the age of 6 years. From 6 to 14, it is covered in Article 21A. Up to 6 years, Article 45. 46 is for scheduled caste and tribes. 47 is prohibition of drugs. Okay, and 48 is organization of agriculture and animal husbandry on modern and scientific lines. 48 is protection and improvement of environment, safeguarding forests and wildlife. That is 48A. 49 is protection of monuments and places and objects of national importance. 50 is also very important. Separation of judiciary from executive. This is also frequently asked question. Separation of judiciary from executive. 51 is promotion of international peace and security. So all these articles, including any sub-articles, you have to have it by heart. So the idea of welfare state in the constitution is enshrined in the directive principles of state policy, and that too particularly if you are talking about Article 38. Okay, state to secure a social order for the promotion of welfare of the people, minimize inequalities in income, status, facilities. So Article 38. Okay, more specifically, directive principles of state policy talks about the ideal of welfare state in the Indian constitution. So which one of the following is not a feature of the Government of India Act of 1935? So we have already seen in 1935. Okay, so in 1919 bicameralism was introduced and it was further extended. Bicameralism was further extended to 6 out of 11 provinces in GOI 1935. So diarchy was established in provinces. Here diarchy was abolished in provinces and diarchy was introduced in the center. And also in Government of India Act 1935 is a very important act, provided for establishment of All India Federation consisting of provinces and princely states. Residuary powers were given to the viceroy, abolished diarchy in the provinces and introduced provincial autonomy in its place, introduced responsible government in provinces. Okay, introduced bicameralism, and in 6 out of 11, principle of communal representation was extended. So for the first time, it was given to Muslims in 1909. It was further extended to 6 Anglo-Indians, Christians, and etc. in 1919. Here it also extended by providing separate electorates for depressed classes. That means within the Hindus also separate for scheduled castes, women, and labor. So this was opposed by Gandhiji. Okay, only for Muslims. Okay, see, 1909 only for Muslims, 1919 for 6 Indian Christians, Anglo Indians, etc. And in 1935 they tried to do it even within the Hindus. Okay, even within the Hindus, separate for scheduled caste, separate for women labor. So further divide and rule. Okay, so abolished the Council of India established by the GOI Act of 1858. So immediately after the revolt, established the Reserve Bank of India. Okay, this is one thing. Remember, and established the Federal Public Service Commission. Federal Court was set up in 1937. Okay, Supreme Court was set up in 1774, right? That is different. This is Federal Court. So the question is, which of the following is not a feature of Government of India 1935? So diarchy at the centers as well as in the provinces. So basically, diarchy was in 1919. Diarchy was introduced in the provinces. So in 1935, diarchy was abolished in the provinces, and provincial autonomy was introduced in its place. So this is correct. And diarchy was introduced in the center. So this is also correct, but not in the provinces. So option 3 is not a feature. Bicameral legislature, we have already seen for the first time in 1919, 1919, that is the Montagu Helmholtz reforms. It has been introduced and it has been extended to 6 out of 11 provinces in 1935. All India Federation also we have seen. Federal court has been set up. Okay, so option 3 is the wrong one. Diarchy is there at the center but not in the provinces. So the members of the Constituent Assembly which drafted the Constitution of India were elected by the legislative assemblies of various provinces. Okay, so when the idea to form the Constituent Assembly came forward, those members of that particular assembly were elected by the legislative assemblies of various provinces. So already the elections were taking place for various provinces. Okay, and people were getting elected. The Indian National Congress, sometimes the Communist Party. Okay, in Andhra, we have the Justice, okay, so Justice Party and all these things. So several elections have already been taken. So there are respective assemblies and the MLAs. Okay, so they elected the members of the Constituent Assembly. Okay, they are not nominated. Or they are not elected by INC or anything. So they are elected by the legislative assemblies of various provinces. This is we are talking about the Constituent Assembly, which was formed to draft the Constitution. Okay, Dr. B.R. Ambedkar is the head of the drafting committee, chairman of the drafting committee. So the power of the Supreme Court of India to decide the disputes between the center and the states, okay, falls under the original jurisdiction. So and when I said Supreme Court, you have to remember a couple of articles starting from Article 124. Okay, especially for Group 2, you have to multiple times you have to see. So Article 124 talks about the establishment and constitution of Supreme Court. Okay. Next important thing is 130 is the seat of Supreme Court. 131 is the original jurisdiction of the Supreme Court, very important. And 132 is the appellate jurisdiction of the Supreme Court. So within this original jurisdiction, all that comes. Okay, we'll look into that. And 136 is special leave to appeal by Supreme Court, very important. Okay, because with this special leave, any case you can go to the Supreme Court. So this is a very important power. Next, 141. Okay, law declared by Supreme Court to be binding on all courts. So this shows that there is a unified judiciary in the country. 142 is a very supreme power of the Supreme Court. Okay, so not just giving the orders, but it can also enforce the orders. Okay, so this is very important. 143 is the power of president to consult Supreme Court. So basically, the advisory jurisdiction of the Supreme Court. So 143 is advisory jurisdiction. 131 is original jurisdiction. 132 is appellate jurisdiction. So in this original jurisdiction, see, imagine if you have a center and the state. Okay, then for the dispute, you can't go to the state high court or the district court, right? Because that particular state high court is dealing with that particular state only. So any dispute between two states or center in the states, okay, all those things go to the Supreme Court directly. So that is the original jurisdiction of the Supreme Court. Advisory jurisdiction is Article 143. Appellate jurisdiction is Article 132. 132. Okay, so constitutional jurisdiction in general, you can say 124 and all those things. And also you can say Article 32 is the bridge jurisdiction of the Supreme Court. Very, very, very important. Okay, Article 32 and 226 for the High Courts. Okay, so the power of the Supreme Court to decide disputes between the center and the states falls under original jurisdiction. So which one of the following is part of the electoral college for the election of the President of India, but does not form part of the forum for his impeachment? So again, as we've discussed on the President, while electing the President, everyone who is an elected person participates in the election of the President. That means, see in India, in Lok Sabha and Rajya Sabha, we have nominated members. In Lok Sabha, we have two members. President nominates two members from the Anglo-Indian community, and in the Rajya Sabha, the president nominates 12 members from various departments like social, art, and etc. We've seen. So those nominated members do not participate. So in the election of the president, all the elected members from the Lok Sabha, Rajya Sabha, state legislative assembly, council, union territory, everything. Okay. So everywhere where there is an elected person, they participate in the election of the president. Okay. So when it comes to impeachment of the president, because president is part of the parliament. Okay. What is the parliament? President plus Lok Sabha plus Rajya Sabha. So president is neither a part of Lok Sabha nor part of Rajya Sabha, but he is the part of parliament. So if you want to impeach the president, only those people in the Lok Sabha and the Rajya Sabha participate in the impeachment, both elected and nominated. So which one of the following is part of the electoral college of the election? So state legislative assemblies, the MLAs are the elected MLAs, the two, not the nominated ones. If there is a, I mean, the governor can nominate one person, okay, one Anglo-Indian to the state legislative assembly also. Okay, so all those elected members of state legislative assembly, they participate in the election of the president, but in the impeachment, these people don't participate. Okay, so in the impeachment, only Lok Sabha and Rajya Sabha they participate. State legislative councils they don't participate in the election or impeachment of the president. Okay, so for the election of the president, all those who are directly elected, and for the impeachment, only those who are part of the parliament, that is Lok Sabha and Rajya Sabha. Fine. So when the Chief Justice of a High Court acts in an administrative capacity, he is subject to discretionary powers of the governors of the state. Fine. When the Chief Justice of a High Court acts in an administrative capacity, he is subject to the discretionary powers of the governors of the state. The jurisdiction of any other judges, special control exercised by Chief Justice, okay, special powers provided to Chief Minister, nothing. Okay, you can remember this. Okay, the discretionary powers of the governor of the state. So what is the system of governance? The Panchayati Raj setup. So Panchayati Raj, we have all this Ashok Mehta committee, okay, several committees which we have. So let me show you briefly. So Panchayati Raj, if you see, Panchayati Raj signifies a system of rural local self-government to build democracy at grassroots levels in the Constitutional Amendment Act of 73rd, okay, 1992. So first thing is Balwant Committee Mehta, okay, Balwant Committee. Okay, so these are Malhotra committee to establish three-tier panchayat Raj system, Gram Panchayat at the village level, Panchayat Samiti at the block level, and Jilla Parishad at the district. So district level we have ZPTC elections, right, and we have Sarpanch and all those things at the village level. So this is what is the first thing is Balwant Mehta committee, and then you have Ashok Mehta committee, and also Rajasthan is the first state to adopt Panchayat Raj system, followed by Andhra Pradesh. So first is Rajasthan, second is Andhra Pradesh. Then after Balwant Mehta Committee, you have the Ashok Mehta Committee, 1977, and it is suggested for three-tier to be replaced by two-tier. Okay, Ashok Mehta Committee, and then you have GVK Rao Committee, 1985. Okay, and then you have LM Singhvi Committee, 1986, and you have Tungan Committee and Gadkil Committee. Okay, they said Panchayat Raj should be constitutionalized. That's why we have the 73rd Amendment Act of 1992. And there should be three-tier system: village, block, and district. So except Ashok Mehta committee, more or less everyone said there should be a three-tier system, term of 5 years, okay, and maximum supersession of only 6 months. That is, after 5 years is over, within 6 months there has to be elections. Reservation to seats to SC, ST women, etc. A state finance commission to be set up in each state to for devaluation of finances to the Panchayat Raj institutions. Okay, state election commission should be established. Okay, so district collector should be the CEO of the Jilla Parishad. That is given in Tungon committee, and state election commission should be established for conducting elections. This is given by the Gadkil. So Tungan and Gadkil is the latest, and you have LM Singhvi, GV. First, if you start from the beginning, it is Balwant Mehta committee. Okay, Balwant committee, followed by Ashok Mehta committee, GVK Rao committee, LM Singhvi, and Tungon and Gadkil. So it's very important. What is the basics of? Okay. So what is the system of governance in the Panchayati Raj setup? So there is a three-tier structure of local self-government at the village, block, and district level. Fine. Not single, not four, not two. Three-tier system. In India, we have the three-tier system. First one is Rajasthan, followed by Andhra Pradesh. So the concept of public interest litigation bill is originated in United States. Okay. So if there is any public issue you want to go to court where you are not the aggrieved person but the public in general, then you can go for a public interest litigation. So match list one, list two. President of India upholding the constitution and the law. Fine. Judges of Supreme Court faith and allegiance to the Constitution of India. Minister for the Union secrecy of information, and members of Parliament faithful discharge of duties. Okay, this is the oath dated. When the president takes the oath, he takes the oath of affirmation to uphold the Constitution and the law. Okay, in the case of judges, faith and allegiance to the Constitution of India. Okay. For the ministers, secrecy of information. For the members of parliament, faithful discharge of the duties. This is the part of the oath which they take after they get elected or selected. So if the Prime Minister of India belong to the upper house, that is the Rajya Sabha. So in the case of Indira Gandhi ji, okay, Manmohan Singh, everyone, they were from the Rajya Sabha. They are not from the Lok Sabha. So if the Prime Minister of India belong to the upper house, he can make statements only in upper house. This is wrong. Once he becomes a Prime Minister, he can make statements in both upper house and lower house. He has to become a member of the lower house within 6 months, nothing like that. If he is not a member of Rajya Sabha also, then see anyone can be made the Prime Minister. But within 6 months, you have to become a member of either the Rajya Sabha or the Lok Sabha. But if he is already a member of the Rajya Sabha, that is the upper house, then no need of this 6 months Lok Sabha everything. Okay, he will not be able to vote in his favor in the event of a no confidence motion. So that is true because he belongs in the upper house. Okay, and no confidence motion is always presented to the lower house, Lok Sabha, because Rajya Sabha does not get dissolved. Okay, it is a continuing rotating body, so it does not get dissolved. The Lok Sabha, if there is a no confidence motion passed, then the Lok Sabha will dissolve. Okay, but because he is from the upper house, he cannot vote in the lower house. He will not be able to speak on the budget in the lower house because he is the prime minister. He can speak in either house. Okay, so option three is the answer. Which of the following schedules of the Constitution of India contains provisions regarding anti-defection? 10th schedule. Okay, the 10th schedule is called as anti-defection 1985. It's very important. If you look at the schedules, you have to remember all the schedules. Okay. So first schedule is names of the states, names of the union territories, the territorial jurisdiction, and all these things. Second deals with the emoluments, allowances, privileges, and third schedule deals with the oaths or affirmations. Just now the oaths which we have seen, right? The members of state legislature, parliament, okay, judges, faith and allegiance, all that we have seen. Okay. Fourth schedule is allocation of seats in Rajya Sabha to the states and the union territories. Fifth and sixth both related to scheduled caste and scheduled areas and tribes. And this is with specific reference to Assam, Meghalaya, Tripura, and Mizoram. So seventh is division of powers between union and states. Eighth is languages. Okay. Till eighth is the part of the original constitution. Ninth schedule is been acted with the first amendment of the 1951. Okay. So all these acts and regulations which were dealing with the land reforms and abolition of Jamindari system and other matters are included in the ninth. So anything that has been included after April 24, 1973 is now open to judicial review. Okay, before that it is not open to judicial review. This 10th schedule which we are talking about is contains about the provisions related to the disqualification of the members of the parliament and state legislature on the ground of defection. That means you join with one party and after getting elected you join another party. That is called as defection. So this schedule was added by the 52nd Amendment Act of 1985, also known as the Anti-Defection Law. Very important. 10th schedule, 52nd Amendment Act of 1985. It is known as the Anti-Defection Law. 11th is about panchayats. 12th is about municipalities. 29 matters, 18 matters, 73rd, 74th Amendment Act of 1992. So all these schedules you have to literally have by heart. So we are talking about anti-defection law, 10th schedule, 1985. So consider the following statements. An amendment to the Constitution of India can be initiated. Amendment. Okay. Amendment can be initiated both by Lok Sabha and the Rajya Sabha, not in the state legislature. Amendment to the Constitution cannot be introduced in state legislature, but it can be introduced in Lok Sabha or the Rajya Sabha. So the parliament can make any law for the whole or any part of India for implementing international treaties. So when it comes to international treaties, there is no need of any consent. So with the consent is all wrong. Without the consent of any state, okay, with the consent of state not required, consent of all states not required, consent of president opinion not required. Okay, so consider the following functionaries: cabinet secretary, chief justice, chief election commissioner, and the union cabinet ministers according to their order of preference. So Chief Justice of India is always on the high. Okay, then cabinet ministers will come. Next, chief election ministers will come, and then will come cabinet secretary. So even the speaker, okay, even the speaker has a relatively higher position, even though his speaker is just a normal MP or an MLA. When once he becomes speakers, he has a little, I think, seventh position or something. Okay, anyway, the chief justice of India is always in the top. Okay, the president will be obviously the first one. Okay, the order of precedence. So let us also look at the order of precedence. So the, the order of precedence is: first one is president, followed by vice president. Okay, prime minister, governors of the states, former presidents. Okay, deputy prime minister, and then sixth position is chief justice of India and speaker of Lok Sabha. So the speaker of Lok Sabha, once you become the speaker, you are put in the sixth position, which is very high, actually almost equal to the chief justice of India. Then you have the cabinet ministers and chief ministers of states with their respective states. So chief minister is almost equal to the cabinet minister. And then you have deputy chairman, planning commission. So currently Niti Aayog, former prime ministers, leaders of opposition in Rajya Sabha, etc. Even leader of opposition also is quite high. Okay, then comes holders of Bharat Ratna. Next, judges of Supreme Court. Next, chief election commissioner, CAG. Okay, all these things you can see. Officiating chiefs, staff holding, etc. So all this you may not be able to remember. See, members of parliament are 21. Okay, members of parliament at 21. But if you become a speaker, speaker is also member of parliament or member of legislative assembly, right? But once you become the speaker, you jump to sixth position. Okay, become very high. So this way that is about it. Okay. So order of presidents, you can say Chief Justice of India and Speaker, followed by Chief Election Commissioner. Okay, then followed by Union Cabinet Ministers. Okay, is it? No, first Chief Justice of India and then Union Cabinet Ministers. The Cabinet Ministers are above. Okay, see, Cabinet Ministers are top. Chief Justice, then Cabinet Ministers, then you have judges, Election Commissioner. See, Chief Election Commissioner is 9A. Okay, so President, Vice President, Governors, all that we have seen. Then comes Chief Justice. Okay, Chief Justice, and then comes Union Cabinet Ministers. Okay, Chief Election Commissioner, Cabinet Secretary last. So, who among the following was the chairman of the Union Constitution Committee of the Constituent Assembly? So, during the Constituent Assembly, you have this, so many committees, right? Union Constitution Committee, Steering Committee, Powers Committee, Drafting Committee. So, Dr. B.R. Ambedkar, everybody knows Drafting Committee. Okay, Jawaharlal Nehru ji is Union Constitution Committee. Very important. So, which one of the following subjects is under the Union list in the seventh schedule of the Constitution? So you have this union list, state list, and concurrent list, right? So union, when you come to the state list, fisheries, agriculture, public health, law and order, police department, all these things come under the state list. Okay, and all these, what you say, postal department, banking, defense. Okay, all these things will come in the union list. So among these, regulation of labor and safety in mines and oil fields will come under the union list because this requires a certain uniformity throughout the state. Next, so which of the following was given classical language status recently? So at that time, Odisha, I mean Odia, and Tamil has a classical, Tamil, Telugu, Malayalam, Kannada has classical language status. Sanskrit also has, and recently Odia is also there, and then Farsi. Recently, Farsi, that is Persian, has also been added. So which one of the following is the largest committee of the parliament? So always remember Committee on Estimates. Okay, so if you look at the Estimates Committee, it was set up in 1921. Even Public Accounts Committee was set up very early, 1921. And Committee on Public Undertakings, it is 1920s. This is in 1964. Okay, so Estimates Committee is on recommendation of John Mathai. It has 30 members. It is the highest. It is the largest committee of the Parliament. Okay, and Rajya Sabha has no representation. All 30 are from Lok Sabha. So, the Public Accounts Committee has 22 members, and even under Public Undertakings also has 22. 15 from Lok Sabha, 7 from Rajya Sabha. Same 15 from Lok Sabha, 7 from Rajya Sabha. So, this Estimates Committee is highest, 30 members. Okay, and this is Krishna Menon Committee, Public Undertakings. It is 1964. So, which of the following is the largest committee of the Parliament? The Committee on Estimates. Fine. So, when did the Jammu and Kashmir Constitution come into force? On 26 January 1957. Okay, so in 1950, in general, the constitution came into force, right? And later, on 26 January 1957, the Jammu and Kashmir constitution also came into force. So the Persons with Disabilities Act has certain features. Which one of the following is not a feature? So PWD Act, okay, the Persons with Disability Act. The features are barrier-free environment, okay, vocational training and employment, supportive social security measures. So all these are there. There is no provision for loans free of interest, okay. That is not there for the Persons with Disability Act. So, which of the following minorities have been recognized by the Constitution? So, religious and linguistic minorities. Fine, not ethnic, only linguistic, not like that. Okay, both religious minorities and linguistic minorities also are identified by the recognized by the Constitution. So, who appoints the commission to investigate into the conditions of the backward classes? So, these questions are always tricky. Okay, who removes from office, who appoints, and all these things. The problem is it's usually between the president and the what you can say parliament. Okay, usually it gets confusing because president is nominal. Okay, is not exactly executive head. So, though everything is done in the name of the president, it is actually the parliament that takes the decisions. So, it can get confusing sometimes. So, try to observe who appoints the commission to investigate into the conditions of backward classes. It is the president. Okay, just like he appoints the finance commission or any other commission, it is the president who does all this calling the sessions and all these things. Okay, appointing commissions, everything is done in the name of the president. So, which one of the following are recognized minorities in India? So, all these Muslims, Sikhs, Buddhists, Christians, Parsis, and Jains are identified as minorities in India. So, the second backward classes commission is also known as the Mandal Commission. Okay, second backward classes commission is popularly known as the Mandal Commission, where we the 27% reservation and all that. Okay, so read about it in detail. It's also important. Okay, the Mandal Commission is also known as the second backward classes commission. So, according to Article 342(1), who among the following has the power to declare a particular community as a scheduled tribe? So, even without the article, usually who has this power? Scheduled caste, I mean, scheduled tribe, and all this is the president. Okay. So, the president has the power. And let us look at Article 342. So, 324 is Election Commission, right? Very important. Remember, 324 is Election Commission, and 326 is a basis of adult suffrage, that is 18 years of age. So, 341 and 342 is scheduled caste and scheduled tribes. Okay. And 343 is also frequently asked. 343 from here, starting from here, is all about languages. Language of the Union, okay, Commissions, Committee of Parliament on official language. Language of the states is 345. Official communication, special provisions, all these things. So anyway, that is starting from 343. So 341 is scheduled caste, provisions regarding scheduled caste. 342 is scheduled tribes. 342A is socially and educationally backward classes. Okay, so according to 342(1), okay, who among the following has the power to declare a particular community as scheduled tribe? Okay, 342 1. Okay, all 342 is regarding scheduled tribes. In the subsections, part 1 says that it's the president who has the power to declare a particular community as a scheduled tribe. So when was the national policy for the empowerment of women launched? 2001. Okay, even in society we have seen this question, right? 2001. So which of the following are true about the guiding principles of the national policy for children? 2013. Okay, so this national policy for children 2013 and for women 2001. Remember that. And see, it is every child has the right to life, education, protection, and participation, which is true. Every child has universal, inalienable, and indivisible human rights. That is true. So every child has the right to engage in hazardous employment. That is outright fault. With common sense, we can say no child is supposed to work in hazardous employment until he is 18. He cannot work in any factories or anything. Even as adolescent, that is from 14 to 18 or either 16 to 18, he can work in only those conditions which are not hazardous. Okay, so every child has the right to engage in hazardous is outright wrong. With common sense, we can say every child has the right to have mental, emotional, social, and cultural development. Definitely positive statement. So it is correct. So these are part of the National Policy for Children 2013, and National Policy for Empowerment of Women is 2001. So the doctrine applied to determine the encouragement of union list with the state list is called as pith and substance. So these are what you say more constitutional terms, okay, especially used in British, US, I mean, etc. I mean, these are this doctrine of eclipse, all these things. So no need to go into too much depth. Just remain is using the doctrine of pith and substance. Okay, using this doctrine, we will see whether there is any encroachment of the union list with the state list. Just remember that. So special provisions for women and children is not considered as discrimination under. See, Article 14 is right to equality and equal protection of laws. Okay, Article 15 is prohibition of discrimination against caste, gender, sex, etc. All those things. Okay, 16 is regarding employment. So if you look at the fundamental rights, it's very basic. We are talking about 14 is equality before law, equal protection of law. Prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth is 15. Equality of opportunity in matters of employment 16. Abolition of untouchability 17. Abolition of titles except military and academic. Okay, that means this Rao Bahadur, all those things, those titles are no longer allowed. Only academic, that is doctor, okay, all those things, and military, colonel, lieutenant, all those things. Anyway, we are talking about 15. Article 15 is prohibition of discrimination on grounds of religion, race, caste, sex, or place of birth. So, special provisions for women and children is not considered as discrimination under 15.3. So, basically, in 15, what we are saying, you should not discriminate on basis of sex also. That is, whether it is male or female, but you can give positive affirmation to women. Okay, so you should not discriminate whether it is man or women, but in order to provide some support to women and children, you can discriminate. So for women and children, you can give some extra benefits. Okay, so that comes under Article 15.3 because 16 is about employment, 15 is about in general, and 14 is equality. So 15.3, the subsection is exclusively for women and children discrimination. Okay, the term dash in the preamble of the constitution denotes that India is not subject to any external authority. So socialist means we have this distribution of wealth, equal work for equal pay, all those are socialistic principles, liberty of thought, expression, speech, assembly, all those things. Sovereign, we are a sovereign state. That means we are not subject to any external authority. India will take decisions on its own. Okay. So Article 243G is also very important, frequently asked. So starting from 243, you have the panchayats, and before that also we have seen all this is high courts. Okay, all these things we have seen. Anyway, so 243 starts with panchayats. A is gram sabha, B is constitution of panchayats, and C is composition. So how many people will be there, and so C, B, C. D is reservation. Okay, reservation regarding SC, ST, women, etc. E is duration of panchayats. So these questions are frequently asked. You somehow you have to link and remember. Okay, so ED you can remember like that, ED. FD, okay, disqualification for membership. G is GPA, General power of attorney we give, right? So like that you can remember GPA, powers and authority of responsibilities. H is taxes. Okay, H is taxes. This is also very important. And I is Constitution of Finance Commission to review financial position. J is audit of accounts of panchayats. K is regarding elections. Okay, very important. And the L is regarding whether it is applied to union territories, how it can be applied, and all those things. And M is parts which do not apply to certain areas. And N is continuous of existing laws in panchayats. O is bar to interference by courts in electoral matters. So this is for panchayats. So because it is O, 243P starts for municipalities. Okay, and same thing repeats again. Okay, for municipalities, P. Okay, and Z is audit. This then we have seen E is duration. Here it is U is duration. V is disqualification. Okay, ZZ is bar to interference by courts. So from P you have to ZA, B, C to ZZ. Okay, after that ZH you have cooperative societies. This is part 9B. This has been relatively recently added. Okay, and that particular amendment is also very important. We'll look into that. So this is up until ZT you have. Okay, this 244 is regarding administration of scheduled areas and tribal areas. All that. So this you have to remember. Okay, first you have 243 to 243O is panchayats. From P to ZC is municipalities, and from ZH to ZT is cooperative societies. And frequently these individual parts are asked. So, and if we look at which particular amendment, that is also important. Okay, so we're talking about cooperative societies, right? So this is 97th Amendment Act. So 97th Amendment Act 2011. Try to remember that. So 97th gave constitutional status and protection to cooperative societies, and in it made Article 19 right to form cooperative societies fundamental right under Article 19. Okay, try to remember. Normally, Article 19 means we'll think right to speech, expression, residence, movement, association, okay, profession, and all those things. But even right to form cooperative societies is there in Article 19, starting from 97th Amendment Act of 2011. Then 43B we have seen, right? 43A we have seen, and 43B is okay, promotion of cooperative societies. Next, Part 9, 9A. 9 was panchayats, 9A was municipalities, 9B was added. Okay, starting from 243 ZH to 243 ZT. Cooperative Society. This is the 97th Amendment Act. Okay, so 243G. So 243G deals with the powers, authority, and responsibility of panchayats. Okay, we remembered this GPA, right? Okay, GPA. So G for powers and responsibilities. Okay, so AG, BC, CC. Okay, reservation D, ED, FD. Okay, GPA. So here it's talking about Article 243 deals with exercise of powers. Okay, powers and authorities of the panchayats. Election is we've seen election is D, right? No, election is K. Remember that K is elections. K is elections of the panchayats. Next, imposition of taxes. We've seen H, I believe. H. Okay, H is taxes. To impose taxes, H. Elections is K. And what else is there? Elections is K. Constitution of Finance Commission is I. Okay, ICF. You can remember. Okay, I is constitution of, or you can say IFC, like KFC. You can remember IFC. IFC is I means for Finance Commission. So try to remember, at least for panchayats. Try to remember because it is asked frequently, and those who are preparing will certainly answer this question. 243G. We remembered it as GPA, right? So powers and authorities of panchayats. So exercise of powers. Panchayats election is K. Imposition of taxes is H. And Finance Commission we remembered as IFC, right? So 243I is Constitution of Finance Commission. Sikkim was made a state from a union territory by 36th Amendment Act. This also asked sometimes. Okay, so 36th Amendment Act, Sikkim was made a state from union territory. So reservation of seats for women. So reservation is D. We have seen, right, 243. Panchayat means 243, 243 to 243 O. So reservation is D, DR. Okay, remember that D is reservation. So 243D is reservation. 243 O is the last one, bar of interference of courts. 243A means the top one, that is Gram Sabha. 243 is the definition, 243 is Gram Sabha. O is the last one, bar to interference by courts. So all whatever happens in the panchayats, courts should not interfere. Okay, and C is composition of panchayats. Okay, C is composition, and D is reservation. DRCC, we remembered like that. Okay, CC, C for competition. Composition. Okay, and D is for reservation. DR. Service Commission. It's okay. These are at that particular time. No need to remember. So name the committee which appointed to make recommendations on categorization of scheduled castes in AP. So among these is the Justice Ramchandra Raju Commission. Okay. So Justice Ramchandra Raju Commission is for categorization of SSC in AP. Try to remember that. So which state first implemented the Lokayukta? Odisha. Okay. So Odisha first implemented the Lokayukta Act. So Lokpal at the central level, Lokayukta for the state level. Rajasthan first in adopting Panchayat Raj systems. Andhra Pradesh is second. And when it comes to Lokayukta, first is Odisha. Remember that. So which committee recommended for the formation of Central Vigilance Commission? So Dr. Santanam Committee. So Sarkaria Commission. We cross check. So Sarkaria Commission is 1983 only. Okay. Sarkaria Commission was set up in 1983. Okay. And Santanam Committee. Santanam Committee recommended the formation of the Central Vigilance Commission. So these committees, for example, Narsimhan Committee. Okay. Narsimhan Committee means first thing if you have to come to your mind is this banking reforms. Okay, banking reforms, and then there is this Vara Committee. Vara Committee is for reducing corruption among politicians, etc. That is Vara Committee. Regarding with electoral reforms and all those things. Okay, so you have to remember these things. So Dinesh Goswami Committee means, for example, electoral reforms. Narsimham Committee is banking reforms, and you have the Sarkaria Commission, Rajamanar Commission, all these things. Panchi Commission, okay, all those are regarding state relations, and Santanam Committee is regarding central vigilance commissions. Okay, the institution of Lokayukta has not been instituted in the following state. So Uttarakhand, Chhattisgarh, and Karnataka, they all have Lokayuktas. In Nagaland, there is no Lokayukta. Okay, so Niti Ayog is the result of cabinet resolution. Okay, it's not a constitutional body. It's not a statutory body. So if it comes with the law of parliament, that is an act. It is a statutory body, not by presidential order. It is not by constitutional. It's not a constitutional body. So that is in the Lok Sabha or Rajya Sabha, they would have taken a resolution and passed to remove the planning commission and bring in Niti Ayog. So which one of the following is a constitutional body? So among these, National Commission for Scheduled Caste is a constitutional body. Okay. So National Commission for Backward Classes, Minorities and Women is not exactly constitutional body. So National Commission for Scheduled Caste, we've seen I think 341, 342. So 315 is Public Service Commission for Union and States. Okay, these are also important. 312 is All India Services. This is also important. And APPSC, UPSC, all these things are come under 315. So we're talking about. So this National Commission for Scheduled Castes is 338. National Commission for Scheduled Tribes is 338A. Okay, and 338B is National Commission for Backward Classes. So this National Commission for Backward Classes is also now a constitutional body because it was added in 338B. But when this question was asked, okay, this was not still there. That's why. Otherwise, minorities and women is not a constitutional body. National Commission for Scheduled Caste is Article 338, very important. For Scheduled Tribes is 338A, and for backward classes is 338B. Okay, and the Constitutional Amendment Act also try to remember for this backward classes. So one not second Amendment Act, very recent. Okay, this one not second Amendment Act of 2018, 38B, very important. 101 is GST. Okay, 102 is National Commission for Backward Classes, and 102, 104. Okay, 105. Okay, 102 and 105 are related. Try to remember like that. 102 and 105 are somewhat related. So this is about backward classes, and 105 is also giving the power to the state governments to identify socially and educationally backward classes. Okay, so 106 is very recent, 2023. Is giving one third of all seats for women in Lok Sabha assemblies and also in NCT of Delhi. So this has been passed, but it has not yet come into action. It will come into force in the next election. Okay. So 104 is this continuation of scheduled caste and scheduled tribes. What is the reservation of seats in Lok Sabha and Assembly up to 2030. So 103 is economic EWS. Okay, 10% reservation for EWS. So remember in order. So 101 is GST. That try to remember. 101 is GST. 102 and 105 are related. So 102 is regarding the National Commission for Backward Classes. 105 is the state will have the power to identify backward classes. Okay. So 103 is EWS. 104 is a scheduled caste, scheduled tribe extension till 2030. 106 the latest one is women reservation. Fine. So by the time this question was asked, backward classes was not there, but later it was added by 102. Okay. 102nd Amendment Act. Scheduled caste is Article 338. Scheduled tribes is 338A. Backward classes is 338B. So which of the following bodies does not or do not find mention in the Constitution? So all these journal councils, okay, planning commission. Planning commission is has been removed completely. Okay. Okay. So which one of the following of the Constitution of India provides provisions for the creation of all India services? So we have just now seen Article 312. Okay, 312 is all India services, and 315 is APPSC and UPSC, right? 321 is power to extend functions of public service commissions. Okay, so that is 321 and 320, 300. 300. So 300 is suits and proceedings that is part of this. What is a contract obligations? Anyway, 300A is persons not to be deprived of property. So they've taken the right to property as a fundamental right has been removed, and it was added as a 300A as a legal right. Okay. And the 315 is regarding this APPSC and UPSC and all those things. And the 320 is functions of public service commissions. What are the various functions and power to extend those functions of public service commissions? For example, if you want to, I mean, if a particular, for example, APPSC, there is no proper commission, then the power of the UPSC can be extended to conduct exams for APPS also. Like so that is the power to extend functions of public service commissions. That is 321. Okay, so 320 is powers, 321 is power to extend, 312 is all India services. So all India services is 312, and 300 is regarding suits and proceedings. 300A is right to property. Next, a member of the UPSC can be removed on the ground of misbehavior by the president on the basis of inquiry by the Supreme Court. Okay, so UPSC members and APPSC members cannot be simply removed. Okay, it has to be removed by the president on the basis of inquiry by the Supreme Court. So, which one of the following is not a part of the state list in the 7th schedule of the Constitution? So, disabled, unemployed, so these unemployment pensions, disability pensions, all these things are provided by the state government, right? So that is a state list. Taxes on lands and buildings is in state list. Prisons is in state list. Agriculture, okay, agriculture, law and order, police, all those things are state list. Prisons also state list. Stock exchange is centralized, right? Stock exchange, banking, SEBI, RBI, postal department, defense, all these things which require a certain what is the uniformity throughout the India. They are all usually under union list. Okay. Next, if you look at 123rd question, which of the following is not a salient feature of the Constitution? So, written Constitution, true, distribution of powers. Okay. Schedule 7, committed judiciary. Okay. So, we have a unified judiciary. So, among these options, a committed judiciary. There is no such thing as committed judiciary. We have a unified judiciary, and we have a procedure established by law, which we have taken from the Japanese Constitution. In the United States, we have due process of law. That means wherever the process takes you. But here, we have a procedure established by law. That means whatever are the rules and regulations, you have to follow that. So, salient features of the Indian Constitution provide for single citizenship for whole of India, which is true. Unique blend of rigidity and flexibility, which is true. Strictly federal form of government. So we have a flexibility also. So it is not a strictly federal form. So we have a central list, okay, which is a unitary form. We have the concept of governors, okay, all India services. All these are unitary tendencies of the blend of rigidity and flexibility. So as I said, union list, banking, and all those things. Concurrent list, marriage, because we have state laws and what is this thing? So state list, agriculture, prisons, all these things. So education is again concurrent list because there is no such thing as residuary list. All those which are left are part of concurrent list by default. Education, weights and measures, okay, and these things, forests, etc. So 5 topics and all the other topics which are in concurrent list. Both state government and central government can make laws on education. Okay, so it belongs to the concurrent list. To which one of the following major political parties is the CITU attached to? It is Communist Part of India, Marxist. Okay, I don't think such questions will be asked, political questions. Verdicts of the Supreme Court of India is, and which of the cases have a direct bearing on center-state relations. So if you look at, is basically we have the concept of basic structure of structure of the Constitution. The doctrine was brought about in the Keshwananda Bharti case, 1973. Okay, and SR Bommai is center-state relations. Okay, Indira Sawhney is regarding to the reservation. Okay, and Maneka Gandhi, you have to check. There is a what is a right to privacy also. So all these things you have to remember. So this Maneka Gandhi case is the uh, right to go abroad. Okay, is also part of the right to privacy under Article 21. Okay, so right to go abroad also. So that is Maneka Gandhi case. Okay, so she wanted to go abroad, a journalist. So Indira Sawhney, we have seen reservation. SR Bommai is regarding central state relations. Keshwananda Bharati is regarding what you can say one way related to the right to property also. But in general, it is what propounded the theory of the basic structure of the constitution. Okay, so even though Parliament has the power to amend the constitution, it cannot change the basic structure of the constitution. So, which of the following formed a part of the terms of reference to the Panchi Commission of India? So, these central state relations, Sarkari Commission, Raj Manar Commission, okay, and all these things, and also the recent one, okay. Panchi Commission is the recent one among all those things. So which of the following formed a part of the terms of reference? So panchayat raj institutions, communal violence, integrated domestic market, all these things are part of the central state relations. Okay, and most of these relations they gave regarding the governors also, that governors should not be vice chancellors. Okay, governor should be some other state, preferably someone not politically involved. All these things. Okay, interstate water disputes can be resolved by which one of the following? Tribunals established by the parliament by law. Okay, for interstate water disputes, you don't go to the Supreme Court or anything. Okay, there are tribunals, water dispute tribunals, Krishna Godavari, okay, water management tribunal, all these things. So based on those tribunal efforts, okay. So you don't need to remember, okay, 2017 who was there. Maybe you can look at who is the recent one and try to remember. Identify the solutions, suggestions, or recommendations of the Sri Krishna Committee from the following statements. So Sri Krishna Committee is also very important. Bifurcation of Andhra Pradesh into Andhra and Telangana, separate capital cities for the two states. Okay. So basically, Sri Krishna Committee was done regarding the capital issue of the Andhra Pradesh after the Andhra Pradesh reorganization. So Hyderabad as a union territory. Okay, this was also one of the suggestion. And bifurcation of Andhra Pradesh into Royal Telangana and Coastal Andhra, making Hyderabad part of Royal Telangana. That was also one of the recommendation of Sri Krishna Committee. Okay, remember all those things. So which of the following committee? So we've seen GVK Rao Committee, all these things regarding Panchayat Raj system, right? Okay, so among that, in the GVK Rao Committee, suggested that separation of regulatory and development functions at the district level. That means at the Jilla Parishad level, there has to be difference between the regulatory and development functions. Nagar Palika bill was first introduced in the parliament during the prime ministership of Rajiv Gandhi. Okay, during the prime minister of Rajiv Gandhi, this Nagar Palika bill was first introduced. The Constitution 74th Amendment Act 1992 provides for which of the following committees. So we have seen 73rd is for panchayats and 74th is for municipalities. So within that municipalities, we have municipal committees, ward committees, committee for district planning, and committee for metropolitan planning. So this municipal committee is not there. This ward committee, okay, committee for district planning and committee for metropolitan planning is there in the 74th Amendment Act of. So consider the following committees set up to study the structure, power, and functions to be assigned to the Panchayat Raj institutions. So which one of the following is their correct chronological order? So you've already seen Balwant Rai Mehta is the first, right? So Balwant Rai Mehta, followed by the Santanam Committee, then Ashok Mehta Committee, GVK Rao Committee, then we have Tungon and Gadkari Committee. Okay, we've seen that order. So remember that. First is the Balwant Rai Mehta Committee, and last is the Gadkari Committee. So remember in that way. And GVK Rao Committee, Ashok Mehta Committee, among these two, Ashok Mehta Committee came first. And we also have seen LM Singhvi, okay, LM Singhvi, Tungon and Gadkil, all that. All those are, we try to remember the order also. So match this list 1 and list 2. Okay. So Madhya Pradesh, West Bengal, Uttar Pradesh, Gujarat. So and intermediate panchayats of these respective states. Panchayat Samiti. Uttar Pradesh has this Kshetra Panchayats. Okay. And Gujarat has Taluka Panchayats. Okay. Just try to remember. So the responsibility of preparation of electoral roll rests with the election commission. Okay, not parliament or state government or local administration. Okay. Preparation of electoral rolls rests with the election commission. So in the Lok Sabha elections, who among the following can order adjournment of poll or countermanding of election on the ground of booth capturing? So obviously again election commission. Anything related to election, Article 324, okay, election commission deals with it. The state public commission submits its annual report to the governor. Okay, UPSC submits to the president and state public commission will submit to the governor and they will put it in the parliament or the assembly respectively. Who has become the first Indian state to satisfy constitutional amendment bill on the GST? Okay, Assam is the first Indian state to ratify the GST bill. Try to remember that. Assam is the first one. So according to Dr. B.R. Ambedkar, which article is the soul of the Indian Constitution? That is the Article 32. So according to Dr. B.R. Ambedkar ji, he said Article 32, the writ jurisdiction, okay, habeas corpus, and because anything at the end of the day, all the laws, everything will ultimately go to the Supreme Court. If the Supreme Court can't do anything, no one else can do anything. So how can the Supreme Court be that powerful? Okay, by these writs, habeas corpus, mandamus, prohibition, certiorari, all these things. So Supreme Court is the ultimate guardian of the Constitution. Okay, and 32, Article 32 is the supreme power of the Supreme Court. So Article 31 is repealed. 352 is emergency. Okay, national emergency. 352. 356 is president rule. 29 means we are talking about religion, fundamental rights. 27 cultural and educational rights. Okay, so 27, 20, those are, let's look at fundamental rights. So if you look at the fundamental rights, okay, 25, 26, 27, 28 are right to religion. 29 is 29 and 30 is cultural and educational rights, protection of language, script, and culture of minorities. And 30 is right of minorities to establish and administer educational institutions. So both are regarding minorities. First one is language, script, and culture of minorities. So this 29 is language, script, and culture of minorities. 32 is writ jurisdiction of Supreme Court. 31 is repealed, right? This is 32. Okay, 31 is repealed. 352 is national emergency. Which amendment has been called a revision of the Constitution of India? 42nd Amendment is a constitution because a lot of things happen in the 42nd. Okay, so it's the most comprehensive amendment so far. It is known as mini constitution. Okay, especially after in the 1975 we had the emergency, right? So as a result of that, we had this 42nd amendment. So it is basically Parliament trying to get more powers. Okay, it curtailed the power of judicial review. Okay, and it raised the tenure to 6 years, which was of course later cut down to 5 years in the 44th. Provided for creation of all India judicial service, shifted 5 subjects from state list to concurrent list. This is also very important. Education, forest, protection of wildlife and animals, weights and measures, administration of justice. Okay, everything. So all these things. Balancing committee. That is, it added. So even the preamble was amended only once in the 42nd Amendment Act. Okay, only once, and new socialist secular integrity was added. Fundamental duties were added. Okay, because of the Swaran Singh committee, we've seen all this, right? Fundamental duty K has been added. Fundamental duty K, and all these things we've seen, very important. And the 44th also, 43rd and 44th, when the Janata government came back, okay, it tried to nullify some of these distortions, restore the jurisdiction of Supreme Court, deprive the Parliament of its special powers to make with anti-national activities, all these very powerful Tada Act, Potta Act, and all these things. Okay, so without any warrant, without any bail, you can arrest someone for terrorist activity. Okay, it has been misused on normal people also. Sometimes if you have any political appointment or any journalist or something, you arrest them under Potta Act. Okay, it's very dangerous. So too much power for the government is also not a good thing, and all these things. So 86th is also important. So 86th is this right to education, right? I've told many times. So 86th is this Article 21A, changed the subject matter Article 45 and added a 51A. Okay, this last one, 51A subpart K, and all those things. And 97th is we've seen cooperative societies. Okay, and this 86th is 2002. Remember, okay, 86th Amendment Act 2002. So which of the following determines that the center and the states? Basically, Schedule 4. Okay, no, Schedule 7. I'm sorry. Schedule 7 is distribution of powers between center and state. Okay, talks about the list, union list, all those things, right? If you look at schedules, okay, if you look at the seventh schedule, division of powers between union and states. Union list contains 100, state list contains 61, concurrent list contains 52. So all this is distribution of powers between the central and state is the determining factor for the federal nature. Not the other. Independent judiciary means unitary, vesting of residuary powers with the center, again unitary tendency. It's a rigid, ours is not a written constitution but not a rigid. It is both a blend of rigidity and flexibility. So among the following worked as a central chief information commission. So all these people, Deepak Sandhu, Tiwari, R.K. Madhur, all this. It is said by J.S. Mill. Okay, he said that the Rajya Sabha should be there so as to act as a, I mean, to prevent the Lok Sabha from becoming the dictatorship. So, which of the following countries have bicameral parliament? So, bicameral is basically Lok Sabha and Rajya Sabha, upper house and lower house. So, in USA, Canada, Britain, everywhere there is bicameral parliament. Who is the president of B2 Janata Dal? Naveen Patnaik, even today. Okay. So, on which date the Union Cabinet approved the GST bill? On March 20, 2017. So in general, 2017 everyone remembers. March also people remember, but to remember 20th March it may be difficult. But if you are preparing for Group 2, even then, if you remember as March 2017, it could be enough. Okay, just remember that 2017. On which date Lok Sabha passed the Maternity Benefit Bill 2016 to raise maternity leave to 26 weeks. So who is sworn in as the new Uttarakhand Chief Minister? T.S. Rawat. This is in 2017, this particular paper. So currently we can see who is the Uttarakhand Chief Minister. Okay, fine. So that is about this paper. Thank you.